In the recent times, special intensive revision exercise by Election Commission of India has been the pinpoint of multiple political debates. But this time it has entered yet another constitutional debate where a chief minister has gone straight away to Supreme Court with questions against a constitutional body, that is ECI. And here a direct writ petition has been used to seek answers which were initially asked by the Chief Election Commissioner, and when the Chief Minister was not satisfied with the answer, they have approached the Supreme Court. Now this directly brings an important question in front of us, that what exactly is the situation of special intensive revision, that yet again it has gone to Supreme Court. How can a chief minister take a writ petition to the Supreme Court against a constitutional body? What is exactly unfolding in the larger picture? Hello everyone, welcome to Vajiram and Ravi's Flash News. My name is Shubhangi Singh, and in today's discussion we will be looking into this writ petition, that what exactly it is, why it is being used by a chief minister against a constitutional body, and all the details around it. So let us start from scratch and understand what exactly has unfolded. So Chief Minister of West Bengal, Mamata Banerjee, she has filed a writ petition. She has filed a writ petition in Supreme Court. And when we are talking about this petition, this challenges the special intensive revision exercise of electoral rolls which is being conducted by Election Commission of India. Now this is in specific reference for West Bengal, but when we talk about this whole exercise since last year itself, when it started for Bihar, this has been a ground for political debates and multiple constitutional questions as well. Now in this particular petition, the allegation is that special intensive revision exercise which is happening, it is happening in violation of Representation of People's Act 1950 and also the election rules and laws that have been set up. And this issue is not something that has just cropped up. If you look at TMC, which is one of the major political parties when we are talking about West Bengal, they have consistently been raising that issue. Now in this context, let us try to understand all of this from scratch, understanding that what exactly is special intensive revision. So when we talk about special intensive revision, it is not something that is new. It is a proper verification exercise that is done of electoral rolls. The whole idea is to press the refresh button on electoral rolls so as to ensure that if there are any duplicate or deceased voters, they are removed. If there are incorrect entries, they are corrected. And if the voters have shifted, that change or verification can take place. Now when we are talking about SIR itself, it's not that it is coming out of the blue. It has proper provisions under Representation of People Act 1950 and also Registration of Electoral Rules 1960. Apart from that, when we are talking about constitutional provisions, the powers that have been given to ECI, in that context, that has been verified and also said by the Supreme Court on the same context. So when we are looking at SIR, it is normally justified as on the grounds of electoral purity, and this can be only ensured that if we want to cleanse the electoral rolls, the idea can only be just if the proper process is followed. If proper process is not followed, then there might be scenarios of political gains, and that is the whole core reason of dispute. Now, in this context, when we are talking about dispute related to SIR, it is not just about the power to conduct SIR. I am talking about this specific petition. It is about the manner of implementation that is being questioned. And this is not the first time it is being questioned. This has gone to Supreme Court. Supreme Court has rebuked ECI. There have been certain directions that have been given. All of this has already happened. If you want to understand that in detail, I have already covered it in a video. You can go and watch that in Flash News. Now, in this context, when we are saying the whole issue is about manner of implementation, we need to understand that why SIR is being objected continuously from this particular state and also by this specific political party. So the main concerns we need to focus on the concerns. We need to not focus on the political angles here. The main concerns that have been raised are fact that if we talk about electoral officers, they are acting with informal and also unwritten instructions. So these instructions are not laid out anywhere, and that is why what is happening, that exclusion is happening of genuine voters, which is going to impact certain party in a way. Another thing that has been highlighted as a concern is the fact that voters which are being excluded, there is just cases of logical discrepancy, but at the same time we are also getting to see that they are not getting any clear notice about it. And field level discretion, that means the field officers which are present, they are acting in an arbitrary and excessive nature, which gives them a lot of power to dismantle and change and affect the due process that we are talking about. That if SIR should take place, then it should take place with the proper due process. That is what is being affected here. So the whole fear that is being projected from this particular state by this political party is of the fact that there is exclusion of genuine voters. But if you remember, this is not the first time that this is being highlighted. Now in this context, we need to go back and see that how it has been dealt previously, especially when we are talking about Supreme Court, because this matter has again gone to Supreme Court, but this time it has gone through a writ petition. We will be talking about that also. So Supreme Court, when it dealt this matter previously and it had to intervene, especially after the draft electoral roll was released, multiple deletions were seen. So here key directions were given by Supreme Court to Election Commission of India. The first and the most important one was to ensure transparency. And the verification itself should be transparent. If you think if there is any logical discrepancy, we still want a transparent verification with proper clear notice, which is not happening in this scenario in West Bengal, even though Supreme Court has said this. Apart from this, Supreme Court also wanted that ECI should provide all the affected voters a proper, reasonable opportunity to respond and then finalize the electoral rolls. So if there is a genuine voter, they have a genuine chance to be part of the electoral rolls. Apart from that, we also got to see that Supreme Court clearly said that please avoid any arbitrary deletion of names from the electoral rolls. So if we look at the three directions that were given to ECI, that pretty much sum the situation that we are, some as an answer to the situation that we are seeing in West Bengal. Furthermore, however, even after these directions, as of now, that writ petition which has been filed, it has been filed on the grounds that okay, Supreme Court, you have given the directions, but these directions are not being fully complied with, and this non-compliance is the primary basis of the writ petition that has been filed by the Chief Minister. Now we will move towards the writ petition. For that, first we need to understand what exactly are petitions and how writ petition is different here. So when we are talking about petitions, they are categorized. So when we are talking about a petition, in law, a petition is basically a formal request to the court in regards with something, requesting to do something, asking to take action on something, and we have multiple types of writs. But when we are talking about the most common categories here, the first one we get to see is writ petition. Whenever we are talking about writ petition, it basically means a request is being made to ensure that there is proper enforcement of the fundamental or legal rights which are present. Now we find the mention of writ petition in not just reference to Article 32, but also Article 226. Supreme Court here and High Court here. The only difference in context of writ petition is Supreme Court only take it in terms of violation of fundamental rights, specifically related to fundamental rights. However, High Court can take it for other matters as well. Other than that, we have special leave petition, then we have original suits which are brought in terms of petitions, and our focus of discussion would be on writ petition. So when we are talking about writ petition, When we are talking about writ petition, especially in this context, we get to see that it is invoking the court's constitutional jurisdiction, and that is why the choice of petition also is being used to reflect the seriousness that this is about the constitutional provisions which are being violated, the violations that are taking place. So this is also another idea when the choice of petition also, especially in the political dimension, it is being used to highlight that how serious is this issue. Now in this context, when we specifically move towards writ petition, let us understand this in further detail. As I said, it is a constitutional remedy, Article 32, 226. It is used when a fundamental right is violated. Now in this context, both are approachable, Supreme Court and High Court. But if the matter is apart from fundamental right, then High Court can only be approached through Article 226. In this context, it is very important to remember that it is used specifically when the public authority acts illegally, or they are being arbitrary, or they are crossing the limitations set by their powers. So in this context, it seems just that okay, a writ petition has been filed against ECI, but we have to look into other dimensions as well. Now in this context, we have to go into the deeper detail regarding with writs when we are talking about. So whenever we are talking about a writ petition, it is basically a written order from the Supreme Court or High Court that commands the constitutional remedy for Indian citizens against the violation of their fundamental rights. Now writ petition can be of different types. For example, when we are talking about habeas corpus, this writ is used to enforce the fundamental right of an individual liberty against unlawful detention. So habeas corpus literally means to have the body off. So if there is unlawful detention, then habeas corpus would be used. So when we are talking about election matters, mostly we get to see uses of mandamus and certiorari. In this context, when we are talking about mandamus, it really literally means we command. So this writ is used by court to order that public official who has failed to perform his duty, that needs to be done, or if he has refused to perform his duty, to resume his work, to get his work done. Now the literal meaning of certiorari is basically to be certified or to be informed. So in these cases, this writ is used by a court higher in authority to a lower authority court to give directions. So in this matter, we get to see that mostly presence of judicial and quasi-judicial bodies is there. It is not related to administrative. So we need to see that how exactly this writ petition gradually plays out and what Supreme Court brings in terms of direction. Now one important question when I was reading this article and I wanted to know in detail that can a chief minister go ahead and file a case, writ petition against a constitutional body. So in this context, we also have to understand that when we are talking about chief minister, he is also a citizen of this country, and based on our constitutional provision, yes, this is allowed. Because the main principle here is that election commission is an independent body. It is immune from judicial review. No, it is not. It is independent, but it has to follow constitutional provisions. So in this context, a constitutional body needs to act within the parameters set by the constitution, by the statutory law, and also the principles of natural justice. So if a citizen is aggrieved, then constitutionally definitely he or she is permitted to reach out to the Supreme Court. So here chief minister can go out as an individual, or he can go as a constitutional authority as well, which is affected by another authority's action. So these are the two ways where this is a possibility, and that is why the legality of this petition stays absolutely intact. Now on this note, I would like to ask you, now on this note, we would be moving further to address another dimension around it, that why in this scenario, Bengal SIR case, we are again looking into the constitutional lens, because it is very important for a democracy so as to ensure the fairness in elections. That is one of the most important foundations. So if there are questions against the fairness of electoral process, yes, it is important to raise the question. If there are any limits on ECI's administrative discretion, the questions are around that, yes, it becomes constitutionally important. And if Supreme Court has already intervened, given directions, and you are not following it, then again it raises constitutional questions. So in this context, it is very important to look into that, no, this matter is not just about a political angle, a political debate, it is about constitutional significance. It has a very important federal dimension around it, where it shows that if there are tensions between state government and central constitutional authority, how difficult the functionality of a democracy comes in, how difficult the functionality of a federal country comes into the scenario. So all of these dimensions are very important from the perspective of exam also, and for the perspective of getting deeper understanding and clarity on this topic as well. Now I hope you have got a fair clarity on this. That was all from my end. Thank you so much.